Good afternoon and welcome to the weekly business meeting of the South Carolina Public Service Commission. Thank you for joining us. Today is Thursday, December 5th, 2024. It's approximately 2 p.m. Before we begin, would you please join me in a moment of silent reflection? Thank you very much. First, a roll call. The commissioners, all commissioners are present here in the hearing room. Ms. Scarborough, if you would, please proceed.
Good afternoon, Chair Powers, Vice Chair Williams, and Commissioners. First order of business is to set the next regularly scheduled business meeting. Staff recommends that the next commission business meeting be set for Thursday, December 12th, 2024 at 2 p.m.
The next business meeting will be Thursday, December 12th at 2 p.m.
Thank you. Today we have 10 items on the utilities agenda and 8 items on the transportation agenda. Item number 1 on the utilities agenda is in docket number 24-18E. This is a motion for admission pro hoc vici of Dorothy E. Jaffe, Esquire, and Sari Amiel, Esquire, filed on behalf of Sierra Club.
All right. Having heard item 1, is there a motion?
Chair Powers?
Commissioner Williams.
Thank you, Chair Powers. I move that the Commission grant the motion of the Sierra Club for admission pro hoc vici of Attorney Dorothy E. Jaffe and Attorney Sari Amiel.
Thank you very much. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed, no. The ayes have it. The motion passes.
Item number 2 is in docket number 2024-286E. This is a request from Central Power Electric Cooperative Incorporated for confidential treatment of the direct testimony of William C. Ware.
As to item 2, is there a motion?
Chair Powers, I'd like to make a motion.
Commissioner Casson.
Thank you. On November 18th, 2024, Central Electric Power Cooperative Incorporated filed pre-filed direct testimony of its witnesses in docket number 2024-286E. This included certain portions of the pre-filed direct testimony of William Ware, which Central advises is commercially sensitive and proprietary. I move that the Commission find that the direct testimony of William C. Ware contains information which is commercially sensitive and proprietary. I further move that the Commission grant the request of Central Electric Power Cooperative that certain portions of the pre-filed direct testimony of William C. Ware contains commercially sensitive and proprietary information, and grant the request for confidential treatment of those portions of Mr. Ware's pre-filed direct testimony which are marked as confidential. Accordingly, confidential portions of witness Ware's pre-filed direct testimony are protected from disclosure under the South Carolina Freedom of Information Act and other applicable provisions of law, and the testimony will be maintained as confidential until further order of the Commission. I so move.
Thank you, Commissioner Caston. Having heard the motion by Commissioner Caston, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed, no. The ayes have it and the motion carries.
Item number 3 appears in docket number 2024-287E. This is a request from Duke Energy Carolinas, LLC for confidential treatment of the direct testimony of Matthew Knudsen.
Thank you. As to item number 3, is there a motion?
Mr. Chairman,
Commissioner Belser.
Duke Energy Carolinas LLC filed a pre-filed direct testimony of its witnesses in docket number 2024-287-E on November 18, 2024. DEC advises the Commission that certain portions of the pre-filed direct testimony of Matthew Knudsen contains commercially sensitive and proprietary information. I move that the Commission find that the direct testimony of Matthew Knudsen contains information which is commercially sensitive and proprietary, and grant the request for confidential treatment of those portions of Mr. Knudsen's pre-filed direct testimony which are marked as confidential. Accordingly, the confidential portions of witness Knudsen's pre-filed direct testimony are protected from disclosure under the South Carolina Freedom of Information Act and other applicable provisions of law, and the testimony will be maintained as confidential until further order of the Commission. So move.
Thank you, Commissioner Belser. Having heard the motion by Commissioner Belser, is there any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed by no, the ayes have it, the motion carries.
Item number 4 appears in docket number 2024-5G. This item involves final disposition of this docket.
As to item number 4, is there a motion?
Chair Powers.
Commissioner Thomas.
Thank you. I move that the commission find Dominion Energy South Carolina Incorporated's gas purchasing policies and practices during the review period were reasonable and prudent. Further, I move that the commission find the following. The company properly adhered to gas cost recovery provisions of its gas tariff and within the guidelines established in prior commission orders. Dominion Energy also correctly adjusted the gas cost recovery factors for each customer class in accordance with the terms of order numbers 2006-679, 2009-910, and 2023-737A, which factors are hereby approved. The demand charges included in the total cost of gas factors should continue to be calculated as set forth in Commission Docket Number 2023-70G, Order Number 2023-737A, by allocating such costs among the rate schedules based upon the forecast peak design day demand. The monthly adjustment procedure and notification procedure for the total costs of gas factors as adopted in order number 2006-679 as modified by order number 2009-910 and further modified by order number 2023-737A shall be maintained. The appropriate cost of gas calculations for the review period are set forth in Hearing Exhibit 3. The allocation factors contained in Witness Smith's direct testimony on page 4 are appropriate and should be utilized for cost of gas calculations beginning with the first billing cycle of January 2025. DESC shall continue to charge and recover carrying costs, if applicable, on the cumulative total over or under collection balances in the same method and with the same limitations as set forth by the Commission in docket number 2006-5G, order number 2006-679. In the event of an over collection balance, carrying costs should be credited to customers. The actual balance in the company's unbilled gas adjustment cost account shall continue to be applied to the PGA over-under collection calculation, and the company shall consider this unbilled gas cost adjustment account in all future PGA calculations. Future monthly adjustments shall continue to be applied to the demand component of the cost of gas factor. Finally, I move that we direct staff to prepare an order consistent with our motion. So moved.
Thank you, Commissioner Thomas. Having heard the motion by Commissioner Thomas, is there any further discussion? Hearing
Mr. Chair.
none,
Mr. Chair,
all those in favor signify by saying
Mr. Chair, I'm sorry, Mr. Chair. Just wanted to
Vice Chair Williams.
state that I won't be voting. I was on annual leave during this hearing. Thank you.
Thank you very much. All right. All those in favor signify by saying aye.
Aye.
Any opposed by no, the ayes have it, the motion carries.
Item number 5 has been deleted from the agenda. Item number 6 appears in docket number 2024-247W. This is a request from Upstate Water Resources Incorporated for confidential treatment of the personal financial statements of James C. Burton.
As to item number 6, do I hear a motion?
Chair Powers.
Commissioner Caston.
Excuse me, thank you. I move that the commission find that the personal financial statement of James C. Burton contains information of such a personal nature. The public disclosure would constitute an unreasonable invasion of personal privacy and a personal identifying information which should be protected pursuant to South Carolina Code annotated Section 30-4-40 and prior orders of the Commission. I further move that the commission grant the request of Upstate Water Resources for confidential treatment of the personal financial statement of James C. Burton, and that Mr. Burton's personal financial statement is protected from disclosure under the South Carolina Freedom of Information Act and other applicable provisions of law. The financial statement will be maintained as confidential until further order of the commission.
Thank you, Commissioner Caston. Having heard the motion by Commissioner Caston, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed by no? The ayes have it. The motion carries.
Item number 7 involves the commission establishing a docket to comply with South Carolina Code annotated section 58-40-20E concerning net energy metering, which requires the commission to revisit every 5 years the methodology used to value the energy produced by customer generators.
As to item 7, do I hear a motion?
Mr. Chairman,
Commissioner Belser.
subsection E of South Carolina Code Annotated, section 584020 requires the commission to revisit the methodology for calculating the value of energy produced by customer generators every 5 years. The docket to establish the methodology for calculating the value of solar was docket number 2019-182E. The hearing in that docket was held in November 2020 and an order was issued in 2021. I move that the commission instruct the clerk's office to issue a notice of status conference to interested stakeholders to provide comments regarding a procedural schedule to revisit the methodology for calculating the value of energy produced by customer generators as required by Code Section 58-40-20E. The clerk's office is instructed to serve a copy of the notice on the Office of Regulatory Staff, the Department of Consumer Affairs, and the parties in docket number 2019-182-E. So move.
Thank you, Commissioner Belser. Having heard the motion by Commissioner Belser, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed by no? The ayes have it. The motion carries.
Item number 8 involves setting the dates and time of the commission's regularly scheduled business meetings for 2025.
As to item number 8, do I hear a motion?
Chair Powers.
Commissioner Williams.
Thank you. I move that the commission adopt the following schedule for its 2025 regularly scheduled commission business meetings on the following Thursdays and beginning at 1 p.m. Month, January, the 9th, the 16th, and the 30th. February, 6th and 13th. March, 6th, 13th, and 20th. April, 3rd, 10th, and 17th. May, 1st, 8th, 15th, and 22nd. June, 5th, 19th, and 26th. July, 10th, 17th, and 24th. August, 7th, 14th, 21st, and 28th. September, 11th, 18th, and 25th. October, 2nd, 9th, 23rd, and 30th. November, 6th, and 20th. December, 4th, 11th, and 18th. I so move, and I have a very minor comment.
Commissioner Williams, you have the floor.
Thank you. In reading all those numbers and dates, probably the most significant thing is the shift from a 2 p.m. business meeting to a 1 p.m. business meeting. And it's my understanding that the goal of doing that is for the clerk's office to be able to issue more of the directives in the docket on the day that these decisions are made. And that 1 hour is, we hope, going to make a difference. Thank you.
That's correct. Thank you, Commissioner Williams. Having heard the motion by Commissioner Williams, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed, no. The ayes have it. The motion carries.
Item number 9 appears in docket number 2024-192E. This item involves final disposition of this docket.
As to item number 9, do I hear a motion?
Mr. Chair.
Vice Chair Williams.
Thank you, Mr. Chair. Mr. Chair, fellow commissioners, I move that the commission grant the request of Dominion Energy South Carolina Incorporated for approval to continue its portfolio of demand-side management programs including approval of a new residential demand response program and reaffirmation of its demand side management rate rider with the following modifications. Dominion may recover through the DSM rate rider its costs incurred in providing DSM programs, net lost revenues, and a shared savings incentive of 9.9% of the net benefits of the DSM programs. The shared savings incentive is to be amortized over 5 years without interest or carrying costs and added to the calculation of the DSM rider. Number 2, DSM program costs shall be recorded on the company's books as a regulatory asset and amortized over a 3-year period. And number 3, Dominion shall apply carrying costs to the unrecovered balance of DSM program costs at the company's weighted average cost of debt. Number 4, Dominion shall continue to amortize for rate recovery the unrecovered balance of DSM programs costs over a 3-year period by vintage as approved by Commission Order number 2019-880. Number 5, qualifying non-residential customers may opt out of Dominion's DSM programs in accordance with Order number 2019-880, with the exception that a non-residential customer must remain in the programs for a minimum of 3 years from the date the customer accepts the DSM incentives or other DSM benefits from the company. Current opt-out notifications presently in effect for non-residential customers will remain in effect under the reauthorization of the rate rider. Number 6, Dominion shall recalculate the benefit and cost test calculations for each individual measure and the portfolio as a whole after correcting the annual avoided capacity cost data as discussed in rebuttal testimony of ORS witness Cutter and consistent with the avoided capacity cost data in rebuttal exhibit EAC-1, including avoided T&D costs within 30 days of the commission's order. Number 7, upon recalculation of the benefit and cost test calculations in accordance with the previous ordering paragraph, should any programs within the proposed EEDSM portfolio have a TRC less than 1, the company shall address necessary improvements to increase cost effectiveness with the Energy Efficiency Advisory Group and propose any modifications by its 2026 annual update filing. In subsequent 5-year authorization requests, if the company includes T&D costs as avoided capacity costs, it shall confirm the hours of greatest T&D need coincided with the hours of greatest generation need or generate separate generation capacity value and T&D capacity values for each EEDSM measure category or load shape. Number 9, the company is authorized to modify and amend any measure or program to its suite of programs without the requirement of seeking prior commission approval. However, the company shall contemporaneously report such changes to the commission and include the information in the commission's annual report, in the company's annual report to the commission and the Office of Regulatory Staff. Further, the company shall seek commission approval prior to terminating or adding any program. And finally, number 10, Dominion's proposed programs are approved for a 5-year period. So moved, Mr. Chairman and fellow commissioners.
Thank you, Vice Chair Williams. Having heard the motion by Vice Chair Williams, is any further discussion?
Chair Powell.
Commissioner Caston.
If Vice Chair Williams, would you consider an amendment to item 1 in your motion, revising from 9.9% to 7.93%?
Well, I'd love to hear the basis for the amendment, and okay, while doing so, consider it.
Thank you for the opportunity to do that. I believe, from the testimony that the 7.93% provided the most tangible details as to why that number should exist or be. The 9.9%, in my view, reviewing the testimony and hearing it, was there was no substantiation for the number other than just stating it. So I do believe the 7.93 is a more appropriate incentive.
Chair Powers.
Mr. Thomas.
I would just like to say that I agree with Commissioner Caston. I believe that the 7.93% is the more appropriate number. And I believe that the Department of Consumer Affairs made the best argument that supported that position. So I'm in favor of your change. Thank you.
Thank you, Commissioner Thomas. Any further comments?
Mr. Chair,
Vice Chair Williams.
I appreciate my neighbor, Commissioner Thomas, and my dearest friend from Clemson, Commissioner Caston's perspective on the shared savings incentive. I would like to offer a little perspective on how I reached, I guess, peace, or I'm comfortable with the 9.9 shared savings incentive. When I look at the law that the commission uses to assess these programs, and I'm just going to read it. The commission may adopt procedures that encourage electrical utilities and public utilities. And I'm sorry, I left my computer at home this morning, so I'm working off of a cell phone. So the commission may adopt procedures that encourage electrical utilities and public utilities providing gas services subject to the jurisdiction of the commission to invest in cost-effective energy efficient technologies and energy conservation programs. If adopted, these procedures must provide incentives and cost recovery for energy suppliers and distributors who invest in energy supply and end-use technologies that are cost-effective, environmentally acceptable, and reduce energy consumption or demand. Allow energy suppliers and distributors to recover costs and obtain a reasonable rate of return on their investment, and qualified demand-side management programs sufficient to make the programs at least as financially attractive as construction of new generation facilities. And finally, require the Public Service Commission to establish rates and charges that ensure that the net income of an electrical or gas utility regulated by the commission after implementation of specific cost-effective energy conservation measures is at least as high as the net income would have been if the energy conservation measures had not been implemented. And that's, as you all know, South Carolina Code Annotated Section 58-37-20. I want to focus here on the second bullet point that I read, and I'll read it again. Allow energy suppliers and distributors to recover costs and obtain a reasonable rate of return on their investment in qualified demand-side management programs sufficient to make these programs, and I want to focus here on this part of the sentence, sufficient to make these programs at least as financially attractive as the construction of new generation facilities, at least as, this is my emphasis added, at least as financially attractive as construction of new generation facilities. One thing I will agree with you all on is that Mr. Hall did a fantastic job of laying out his theory of why the company's shared savings incentive should follow the company's rate of return. I thought it was outstanding. Even with me thinking it's outstanding, I think what he helped me see through listening to him and through reading the statute is that this voluntary EEDSM program is here and available, but again, voluntary and not mandated, that the companies offer such programs. And in the case that they do, it seems to me that the law allows some provisions to ensure that the utilities are properly incentivized. And so on the one hand, Mr. Hall argues that the rate of return should be, if I understand his argument correctly, the rate of return should be no more than the allowed rate of return in the utilities last rate case. And in this instance, I believe that number is 7.93%. I would argue that the law states that that rate of return should be at least as financially attractive as the construction of new generation facilities. I interpret that to mean that the floor, the least amount as a way of an incentive that we could grant for the company would be whatever the rate of return would be if they decided to build a new generation facility. And as we know, currently that would be 7.93. And so when I look at it from that perspective, I ask myself this question: what, if any, evidence was produced in the course of the hearing that would suggest that the company's programs over the last 5 years or what they projected for the next 5 years deserve the minimum incentive allowed by law? And when I come back to that question, I don't remember or recall anything that would suggest such. And so if the law calls us to properly incentivize the utility, and at least in my reading of the law, and it sets a floor, and from my reading, it definitely doesn't set a maximum unless, reasonableness, whatever you think is unreasonable, I guess that would be the maximum. But based on Ms. Shelton's testimony, I believe the 9.9% is in line with utilities in this area and may even be lower than utilities in this area. And I think the 9.9 shared savings incentive properly incentivizes the company to pursue such programs, as opposed to walking away from such programs in an effort to construct new generation. But that's not to convince you one way or the other. I just wanted to give you how I interpreted what we received and apply that to the law.
Well, may I respond to clarify some thoughts?
Yes, sir.
I appreciate that. And with the greatest respect, I understand your interpretation. I don't share that interpretation, but relative to incentive, there's a difference between incentive and performance metric. And I don't think you're saying performance metric, but it seems to lean more that way. Relative to, I think, net loss revenue, which is one of the things that the Act also allows the company to recover. In that net loss revenue, that would include the rate of return, to make them whole. To make them whole, the rate of return of the present or existing rate from the latest rate hearing. So that is a given. They're getting that. So along the lines that you're describing, if it was an incentive, not a performance metric, then to get to 9.9, after you have the ROR already, rate of return already in the net loss revenue, an argument could probably be made that it would be 2%, which would give you 9.93. But I guess I believe some distinctions between the way you interpret it and the way I would see it. I don't see that as a floor or performance metric, but rather a simple incentive that, the commission certainly has the prerogative to set. My point being, in the record and in the testimony that was provided, was that Mr. Hall's, during his cross-examination, was the only testimony that provided any basis for a number. The 9.9%, again, just seemed to me to be simply pulled out of the air, not defined or determined. So that's where I was on that and where I am now. So am I understanding that you're comfortable with the 9.9 and you do not want to amend it or adjust it to the 7.93?
Yes, sir. With all due respect. Yes, sir.
I fully understand that. And if, okay, Chair Powers, may I offer a substitute motion that would be identical in verbiage to Vice Chair Williams' motion, except substituting the 7.93% instead of the 9.9%.
Mr.
Well,
Chairman,
you certainly can.
I have a point of order.
Commissioner Belson.
It's not a substitute motion. It would be an amend. He has an amendment to the motion to strike the 9.9 and amend it by inserting his number. It's not a substitute motion.
All right, we can proceed that way. It's either that or substitute motion, but, to amend it, I think we would need to do a vote. I think we should do a roll call vote. Beginning
This
with,
is on the amendment, right?
on the amendment.
Okay.
Strike 9.9 and substitute 7.9 and,
7.93.
7.93. And we would, do a roll call vote, beginning with Commissioner Caston.
A yes vote is agreeing to the 7.93. Yes.
A yes is to amend the motion to include the 7.93, not on the entire motion.
Correct.
Yes.
Okay.
All right, Commissioner Caston votes aye. Commissioner Thomas.
Respectfully, I will be supporting the 7.93%. Yes.
Vice Chair Williams.
Respectfully, no.
Commissioner Carolee Williams.
Most respectfully, no.
Commissioner Belser.
No.
And I vote no, the motion fails.
The amendment.
The motion to amend fails and takes us back to the original motion.
Chair Powers.
Commissioner Williams.
Thank you. Vice Chair Williams, I support your motion, but I have two amendments I would like to propose if this is the appropriate time for that.
I yield to you and the chair. I'll let the chair make that determination, but I believe it is appropriate.
Okay.
You certainly may.
Okay. Based on the testimony that we heard in this docket and my former work associated with energy efficiency, and the roles of goals and of counting the impacts and how essential that is, and also from the perspective that this particular program is now the mechanism will be in place for 5 years. So with that background, I have two amendments I would like to make. They would follow your motion, and so they would pick up after number 10, which Vice Chair Williams read as Dominion's proposed programs are approved for a 5-year period. So that is the same. And then 11 would be the Commission finds compelling the importance of achievable goals that inspire new efforts, new contacts, and new efficiencies. We order continued stakeholder engagement through the Energy Efficiency Advisory Group with other interested parties regarding the development of impactful and achievable goals, and provide an update to the Commission on such initiatives at the time of the 2026 EEDSM annual report. Number 12 would be, finally, we order the parties to further assess the policy of opt-outs and its impact on EEDSM programs and cost. As part of their assessment, the parties should specifically consider and address the information Dominion Energy South Carolina should be required to obtain from customers in its opt-out form, and how or whether this information should be utilized in determining eligibility for customers to opt out of the company's EEDSM program. The company shall address these issues and any recommendations as part of the company's 2026 EEDSM annual report.
Having heard additional items 11 and 12, is there any further discussion?
I have a little bit of discussion. Commissioner Williams, thank you for your amendments. On item 11, would you be comfortable striking the first sentence? And here's why I asked that question. When I go back to the transcript and I read, I think it's is it Gravatt or Gravitt? I always forget. Gravatt?
I think it's Gravatt.
Gravatt. There was a camp Gravitt in Aiken County where we used to go play football or have football camp, and I always want to say Gravitt. Sorry, Mr. Gravatt. There seems to me to be a very difference of opinion between Mr. Gravatt and Ms. Shelton regarding the Energy Efficiency Advisory Group and what's offered there.
Right.
And I really don't want to get in the middle of that. Regarding the importance of achievable goals and inspiring new efforts, new contacts, and new efficiencies, that language, in my opinion, leaves a lot to interpretation. And I would feel more comfortable if we just went with, we order continued stakeholder engagement and so forth and so on, as you read, because to me, what that says is even though you guys obviously do not agree, keep working.
Right. Right.
I'm just asking, is that?
That's acceptable to remove the first sentence.
Well, I will accept item 11. Now,
May I comment on number? Can we take these in order?
yes, ma'am. I'm sorry.
I don't disagree with what you've proposed, Vice Chair Williams, Commissioner Carol Lee Williams. I don't understand I think you said the development of impactful and achievable goals. I'm not sure what impactful means there. I mean, achievable would not just the development of achievable goals work? Because what I might consider impactful, you might not.
But we don't, I hear you, and it's not
And I know there was testimony similar to this in the record, is what I recall, but it's...
You know, there was also a proposed recommendation that I personally found was not as fleshed out as it could be and as defensible. And this was my way of saying, you know, as Vice Chair Williams mentioned, these two parties have been working. Go back and work some more. But I really think it's in the eye of the beholder, and I'm really leaving this to Dominion Energy South Carolina to determine that.
Okay.
I think
I
that,
withdraw my concern.
okay,
Thank you for listening.
no, thank you.
Vice Chair Williams, as to item 12, or should we vote on these things separately? Did you have them?
I just had, it's up to you, Mr. Chair. I just had a question about item 12. If I get the answer that I think I'm going to get, I think I'll be fine with it. May I proceed, Mr. Chair?
Yes, go ahead.
Commissioner Williams, I'm going to read what I believe I heard on the first sentence of item 12. Finally, we order the parties to further assess the policy of opt-out, and its impact on EEDSM programs and costs, period. Is that
Correct.
okay? I'm fine with item 12.
Could you do 11 and 12 as it will be in the motion? Read it one more time as it will be in the motion, so I'll make sure.
Yes, sir. If I may, Commissioner Williams, what I'm willing to accept, fellow commissioners, Mr. Chair and fellow commissioners, for item 11, we order continued stakeholder engagement through the Energy Efficiency Advisory Group and with other interested parties regarding the development of impactful and achievable goals, and provide an update to the Commission on such initiatives at the time of the 2026 EEDSM annual report. And that's item 11. And item 12, finally, we order the parties to further assess the policy of opt-outs and its impact on EEDSM programs and costs. As part of their assessment, the parties should specifically consider and address the information DESC should be required to obtain from customers in its opt-out form, and how or whether this information should be utilized in determining eligibility for customers to opt out of the company's EEDSM program. The company shall address these issues and any recommendations as part of the company's 2026 EEDSM annual report.
All right, and rather than voting on an amendment, we'd be voting on the motion that you now propose with 11 and 12. Is that correct?
Well, I think we would vote on the amendments.
Okay. Well, we'll do that. Then we're going to move as far as a motion to add 11 and 12 as made by Commissioner Carol E. Williams. Proceed to a roll call vote, beginning with Commissioner Williams.
And as amended on the floor.
No, we're just voting on the amendments, right?
No, I meant the amendment that I agreed to.
Oh, okay, I'm
Right.
sorry.
It just,
I'm confused.
does that make sense now? I'm
Yes.
really just, we're, the edits that were made.
Yeah, the vote would be to add the amendments to the earlier motion by by Vice Chair Williams.
Aye.
Commissioner Belson.
Aye.
Commissioner Caston.
I'm still trying to process it, but aye.
Commissioner Thomas.
Aye.
Vice Chair Williams.
I vote aye.
And I vote aye. The motion carries.
Item number 10 is in
Now we need to vote on the motion that includes the amendments. We'll begin with Vice Chair Williams.
Aye.
Commissioner Carol E. Williams.
I vote aye.
Commissioner Belser.
Aye.
Commissioner Caston.
Well, I stated what I would prefer, but I will support Vice Chair Williams' motion.
So that's an aye. Commissioner Thomas.
I would prefer the 7.93, but we already lost that one, so I'm going to support the motion as it is now. Aye, yes.
And I vote aye. The motion carries.
Item number 10 is in docket number 2024-326E, which involves the appointment of a hearing examiner in this docket.
As to item number 10, do I hear a motion?
Chair Powers.
Commissioner Thomas.
I move that the commission appoint Attorney Scott Winburn as hearing examiner in docket number 2024-326C.
Having heard the motion by Commissioner Thomas, is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed by no? The ayes have it. The motion carries.
Mr. Chairman, that completes the utilities agenda before the commission. Moving on to the motor carrier agenda, in Part A, we have 2 applications for new Class C certificates. We can address these items together. Item A1 is in docket number 2024-321T, which is the application of Safe Dependable Care, LLC, for a Class C stretcher van certificate. Item A2 appears in docket number 2024-322T. This is the application of Safe Dependable Care, LLC, for a Class C non-emergency certificate.
As to items A1 and A2, do I hear a motion?
Chair Powers.
Commissioner Caston.
I move the commission approve the applications for Class C certificates in item numbers A1 through A2 as listed by Mr. Scarborough. A directive order will be issued for the application in the respective docket. So moved.
Thank you, Commissioner Caston. Is any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed, no. The ayes have it. The motion carries.
In Part B of the transportation agenda, we have two requests to amend certificates, which can be taken together as well. Item B1 is in docket number 2024-20T. This is a request from Palmetto Car Services LLC to amend Class C Charter Certificate number 9911 to read 15 passengers. And item B2 appears in docket number 2024-217T, which is a request from Palmetto Car Services LLC to amend Class C Taxi Certificate number 9629-A to read 15 passengers.
All right, Mr. Scarborough, I think it's 2021 on that.
It is, thank you, it is 2021-217T. Thank you.
Thank you very much. As to items B1 and B2, do I hear a motion?
Chair Powers,
Commissioner Thomas.
I move that the commission approve the request to amend the passenger restrictions for these Class C certificates to a maximum of 15 passengers, including the driver, in item numbers B1 and B2, as listed by Mr. Scarborough. A directive order will be issued in the respective docket.
Thank you, Commissioner Thomas. Having heard the motion, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed by no? The ayes have it, the motion carries.
In Part C of the transportation agenda, we have one request for reinstatement of a certificate. Item C1 appears in docket number 2019-83T, which is a request from Buddy Taxi LLC for reinstatement of Class C Taxi Certificate number 9444.
As to item C1, do I hear a motion?
Mr. Chairman,
Commissioner Belson.
I move that the commission deny the request of Buddy Taxi LLC for reinstatement of its Class C taxi certificate number 9444. It's been more than 1 year since the motor carrier voluntarily canceled its certificate on May 26, 2023. The motor carrier may file a new application for Class C taxi certificate with the commission. So move.
Thank you, Commissioner Belser. Having heard the motion by Commissioner Belser, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed by no? The ayes have it, the motion carries.
In Part D of the transportation agenda, we have one request for an extension of time. Item D1 is in docket number 2024-227T, which is a request from Palmetto Oaks Adult Day Health Center LLC for a 1-month extension of time to comply with commission rules and regulations.
As to D1, do I hear a motion?
Chair Powers,
Commissioner Caston.
I move that the commission grant the request of Palmetto Oaks Adult Daycare Health Center LLC for an extension of time until January 4th, 2025 to comply with commission rules and regulations.
Thank you, Commissioner Caston. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed by no? The ayes have it, the motion carries.
In Part E of the transportation agenda, we have one request to cancel a certificate. Item E1 appears in dockets number 2022-133T and 2024-302T. This is a request from State Line Medical Transportation LLC to cancel non-emergency certificate number 9709.
As to item E1, do I hear a motion?
Mr. Chair.
Vice Chair Williams.
Mr. Chair, fellow commissioners, I move that the commission grant the request of State Line Medical Transport LLC to cancel its Class C non-emergency certificate number 9709.
Thank you, Vice Chair. Having heard the motion by Vice Chair Williams, is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed by no? The ayes have it.
In Part F of the transportation agenda, we have one request to suspend a certificate. Item F1 is in docket number 2020-127T. This is a request from Charleston Car Service LLC to suspend Class C taxi certificate number 9515-A for 12 months.
As to item F1, do I hear a motion?
Chair Powers,
Commissioner Thomas.
I move that the commission grant the request of Charleston Car Service LLC to suspend its Class C taxi certificate number 9515A until November the 26th, 2025.
Thank you, Commissioner Thomas. Is there any further discussion on the matter? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed by no? The ayes have it.
Mr. Chair and Commissioners, this concludes all business notice before the commission today.
Thank you very much, Mr. Scarborough. We will be back next week, next Thursday. In the meantime, everyone be safe. Have a good holiday. We're adjourned.